And just so you know that this session
Recording
is
in
titled
progress.
To Protect or Harm, the Tensions Between Privacy and Civic Freedoms in Personal Data Protection, and what it means for civil society organizations. So if you think, even if you think that you attend the wrong session, please just stay. Please just stay. My name is Debora. I am project manager for data policy and governance at Tifa Foundation in Indonesia. I will be moderating today's session, and I am assisted by my colleague here, Berna, who will be keeping up with the interactions in the Zoom platform. So before we go to our brilliant four panelists, two are present here and two are online, Anandita and Aris, I would like to just set some context and maybe set the expectations of what we will explore in this session. So countries in Asia Pacific, we have been adopting data protection regulation in our jurisdictions. Some are prompted, some are actually earlier than the others. Some are prompted by what you can call the Brussels effect, which can actually explain how the enactment of the General Data Protection Regulation in the European Union actually has led to the emergence of similar regulations across the globe. And many of us are actually cheering these development or progress of the enactment of data protection law in our jurisdictions. However, in this session, rather than looking at the effectiveness of these laws in addressing the risk of privacy violations, as well as in mitigating the adverse impacts of these violations on the data subjects, we are going to focus on how, despite the virtuous intention behind the development and enactment of such law, there are some provisions that are actually threatening civic freedoms, ranging from freedom of expression, freedom of the press, and so on and so forth. And therefore, such law actually contributes to the shrinking political and operational space within which civil society is actually operating. As we will learn from today's panelists, both online and here, data protection law puts in place legal protection for personal data processing and provides more control of data processing in the hands of data subjects. But the devil is actually in the details of the law. The risks to civic freedoms posed by such law range from unbalanced or disproportionate cost of compliance that are imposed on data controllers in the public, private, and civil society sectors. And another source of risk is actually the potential abuse of the PDP law to silence criticisms and dissents on the grounds of non-compliance or even the failure to prove compliance with the law. So the situation is concerning because civil society organizations in Asia are increasingly becoming data-heavy operations. Therefore, negligence or the lack of capacity to prove compliance actually creates a lot of risk on them, not only financially, but also reputational risk, which can result in the loss of trust from donors and supporters, for example. And we might think of GDPR as the golden standard, but if we can also turn our heads to already happening cases in Hungary and Greece, for example, in which the GDPR has been used, instrumentalized as a SLAP strategy, strategic litigation against public participation, particularly against the media organizations. We can learn from that even if this golden standard itself still pose a lot of risk to the civic freedoms. And learning from these cases, we're going to explore what's at stake in Asia, particularly focusing on Indonesia, the Philippines, and India. And we are going to explore how these tensions of privacy, protection, and civic freedoms in the data protection laws in these three countries can affect civil society and even the civic space itself. And of course, we also want to look forward. We want to find potential solutions to address these problems and challenges and explore how civil society can stay resilient amid this law. And to discuss this, we already have 4 panelists. Present here with us is Maristela Miranda. She is a senior associate from Lights Institute in the Philippines. She regularly assists organizations with their privacy program development on information management, digital security, and community media. She regularly assists organizations with their privacy program development implementation, and she's also a certified information privacy manager. And Ferdhi is the Program and Innovation Unit Manager from Combined Resource Institution in Indonesia. He supervises the implementation of programs on information management, digital security, and community media. And joining us online, Anandita is currently studying law at the New York University. Previously, she was Associate Litigation Counsel at the Internet Freedom Foundation in India, and she has participated in litigation efforts to advocate for the digital rights of Indians. And last but not least, obviously, Aris is Community Engagement Facilitator from Combined Resource Institution in Indonesia with a lot of experience in digital security and community media. I'd like to give the opportunity first to Ferdhi here to explore or to give a preview to us about the privacy threat landscape in Indonesia and how the capacity of civil society organizations for compliance is in the country. Ferdhi, you have 10 minutes.
Okay, okay. Hello. Okay. Okay, good morning, everyone. My name is Ferdhi. I'm from Combined Resource Institution, Indonesia. Here, we are going to share our findings about the readiness of CSOs in Indonesia to comply with personal data protection law. Okay, and
Jasmine, can you please put the slides on?
Yeah, the next slide, please.
Next slide. Next slide.
Next slide, please. Oh, I'm sorry. Control. Yeah. Bisa. Bisa. Mana nih? Yeah, okay, sorry for the technical. Yeah, these are the headlines of data breaches cases. One is a headline from the dark web that happened in the first half of the 2023. It's all Indonesian language, of course, but you can see the numbers like 300 million, like 34 million, 15 million. That's all about the data breaches in Indonesia. And okay, that's the headlines from the BBC News, Tempo, and even from the ministry itself. So 100 million the population and civil registration agency data from the Ministry of Home Affairs were allegedly leaked. 15 million from Bank Syariah Indonesia, customer data allegedly leaked, and there were 35 cases of data leakage in Indonesia from January to June in 2023, said by the Ministry of Communication and Information that responsible for this issue actually. And the situation next on September 10th, the Indonesian government passed the law number 27 of 2022 regulating data protection. This is, of course, a long-awaited regulation because the draft has been made since 2015. Since then, the government and the legislators never reached an agreement about it until Bjorka, if you ever heard about her, the name, the hacker leaked the BPJS Ketenagakerjaan or worker insurance data in 2022. The leak case is just like a catalyst because the government and the legislators thinks they really needs the data protection law right now. And yeah, of course, the CSOs really appreciate the passage of the legislation, but yeah, we have a hope for fair law enforcement for personal data violation, because before 2023 we have a lot of data breaches, but there are no law enforcement. And however, this regulation still leaves loopholes. Okay, next. This is the challenge about the regulations. So the risk to the right to information and freedom of the press. Data protection exceptions don't appear to take press freedom and information rights into considerations. Like for journalists, the media, and the CSOs that engage in advocacy work to expose the abuse of power, this could be threat for criminalization. Yeah, for example, like criminal records and financial data are included in specific data. It would be difficult for the press or CSOs to use it as an evidence of abuse of power or crime by the public officials. Yeah, the government can do anything in this situation, because they could oppress the press of CSOs, even worse, criminalize both in the name of national security, relate to the first one point. So the exemption of the fulfillment data subject, including like national defense and security. And then the enforcement, the next challenge is enforcement on public personal data controllers is too soft, even though the cases of personal data leakage often occur in government organization. And yeah, the last, the Data Protection Authority will be chosen by the president and the regulation, and has the potential to interfere the independence of the institution. Of course, the CSOs and academia hope that the authority is an independent institution, so they could be more free of the conflict of the interest. And yeah, next, the question is, yeah, are the CSOs ready yet? So from the end of 2022 and the early 2023, Tifa and Combine conduct a baseline assessment of personal data protection practices by CSOs in Indonesia in order to arrange a data protection training module for CSOs. And in this assessment, we use survey methods, and there were like 109 respondents from 96 organizations in the sample. The basic assumption is that CSOs are not yet prepared to comply with data protection law, because we are not familiar with this issue. Actually, most of CSOs in Indonesia not really familiar with this. And yeah, about this assessment, of course, it's an initiative. This baseline assessment has limitations. The result cannot be generalized, but at least they can illustrate the situation of the data protection practices amongst Indonesian CSOs. Okay, this is the findings. Yeah, most of them said that this issue is very important. This is a good investment for the CSOs practices in Indonesia. And next, yeah, this is about the second is about technical safeguards that they have in the organization. Like 68% they said didn't have adequate safeguard. 42% answered yes, they have. But this point is very subjective. Of course, the result has to follow up with some technical measurement to answer the can be more valid. Okay, next. Yeah, this is the point about the data policy organization. 58 said they didn't have the specific internal policy regarding personal data protection, and 42 said yes. Yeah, the results suggest that the majority of CSOs that were met responded respondents are still not adequate prepared to protect data, the personal data they manage, which make them more vulnerable to data security incidents. And the last is about the data protection officer. Most of them said no, they didn't have the data protection officer. And yeah, CSOs do not seem to ready to fulfill the mandate of the law. The absence of this function within the organization makes the organization more vulnerable in terms of managing data protection, puts the organization at risk of neglecting the PDP aspects of its work. Okay, this is the last, the analysis. So yeah, personal data protection is seen as a sectoral issue in Indonesia. The lack of awareness of members of the organization for the protection personal data has a serious impact on data protection policies in the organization. Increasing awareness is not enough. It must follow by creating proper internal data protection policy, of course. And CSOs are not ready yet to comply with the personal data protection law. Limited resource, both human and financial, are the possible main barrier. And this law can be a backlash, not only for CSOs who are not ready yet to comply, but also for CSOs who always criticize the government. Okay, that's from me. Thank you.
Thank you, Ferdhi. Later, we will have Anandita. Are you ready to share about how the newly effected, it was just 2 weeks ago, 2 or 3 weeks ago, Personal Data Protection Act in India, how that act may threaten civic freedoms, including but not limited to the freedom of the press, free expression, as well as the right to information. Do we have Anandita's slides ready? Can you please put the slides on India? Sure.
Well, thank you, Debora. I'll start while the slides are being put up, right? Am I audible to everybody?
You are.
Okay, perfect. Good morning, everyone. Okay. This is a heavy early morning discussion, but I will try to keep it as engaging as possible. So the Data Protection Act in India, it was passed, like Debora mentioned, earlier this month. So it hasn't really been a long time. However, it's been going on since a really long time in India. The parliamentary discussions, reports on the bills, so significant changes to the bills over the years that has been going on for a long time, which has finally culminated in this act. There are lots of civil society concerns already about the consultation process, how a lot of views of the experts on the previous existing bills were not taken into account. Some were, and this sort of continues to be one of the concerns that civil society is fighting right now. But without going into detail about that, I would just straight away jump in and tell you a little bit about the act before proceeding into telling you how civil society may get impacted, because right now we really do not have enough data to talk about how civil society is able to comply or not comply with the act. But let's see how it can pan out, right? So starting with what the act protects, the act is called the Digital Data Protection Act, right? And it only pertains to personal data. So non-personal data is not a part of the act at all. It is only protecting data that is being used or that can be used or that is in relation to identification of an individual, right? So that's personal data as defined under the act. Whom does the act apply to? So it applies to any data that is being processed in India after collection. And it also applies to data that is being processed outside India, provided it is in relation to any activity that is offering goods or services to data principles within India. So say it's my data and I am, say, purchasing something on an online website, which is situated out of India. It is processing my data with respect to that purchase in order to make that purchase happen. Therefore, the act will have jurisdiction on that data. I'm sorry, did Bernadette say something?
No,
Okay.
please continue.
Okay, I'll carry on. Yeah. What does it not apply to? It does not apply to personal data of any individual who is processing their own data by themselves, right? So it being publicly available in some capacity impacts the application of the Act. The Act clearly says that personal data that is being made available by the data principal on their own is not within the purview of this Act. So this, makes this question arise in a lot of people's heads. Say you're using Instagram and you're sharing your pictures, but you have a private account, not a public account, but you are putting your own information out there, right? Does the Act protect that? Not protect that? We don't know that yet, right? Okay, so now one of the provisions that the Act has added that helps data principals or provides them a way to enforce their rights is the requirement for consent. So the Act clearly says that a free, specific, informed, unconditional, and unambiguous affirmative action will constitute consent from a data principal to a data fiduciary for processing their data, and that is essential. The data fiduciary has to give a notice to the person in a language that they understand and which is within the Indian Constitutional Schedule 8. And it is only after that consent is given can data be processed. The right to withdrawal has also been granted to the data principal in case they want to withdraw their consent, right? So this is a good provision, in my opinion, to start with, right? Now, this is where the first problem comes in. If you have the slides, it says that data can be processed for certain legitimate uses without the consent of a data principal. So basically, this means that your consent will be deemed to have already been given in certain situations. This starts off very simply in the Act by saying, that for purposes such as you going to a restaurant, giving your number for reservation, it means that you've provided your data voluntarily, and therefore there is consent to process your phone number for the purpose of making that reservation. It starts off like that, but as you keep going down and as you go to slide 6, or, even slide 5.2, it becomes wider and it grants a lot of power to the state to process individual data without their consent. So it states that for the purpose of providing any subsidy, benefits, service, license, or permit, if you have given your data, the state can use it even in future, right, without your consent. Then again, a provision that has been argued to be very broad is that data can be processed with the performance by the state or any of its instrumentalities of any function under law or in the interest of sovereignty, integrity of India, or security of state. Now, these terms in itself are very, very broad and they are not defined and they are very subjective, right? So these provisions can be used in a manner that may be exploitative towards the data of a data principal, right? Similarly, there are more provisions like the data being processed without consent during, say, an epidemic, like if there's a pandemic again, hope so not, but that's when the data can be processed again. So that is something that is really problematic because it is very broadly worded and consent can be assumed without having actually given a notice and taken an individual's consent. Coming to the last slide, there are certain more exemptions that I would just briefly touch upon. I told you already about the consultation process and how there have been problems surrounding that. We've discussed notice, we've discussed the deemed consent, so-called deemed consent provision that existed earlier, which has been changed to certain legitimate uses now, for which consent may not be required. The provision for data transfer right now is not clear. The government will notify a list of countries to whom data cannot be transferred, right? So right now we do not know how that's going to happen, to which countries data can be transferred, etc. Broad exemptions, like I mentioned, or there is very wide exemptions provided for state and its instrumentalities to process individual data, right? Coming to Data Protection Board. So the Act establishes a Data Protection Board. It says that the Data Protection Board will be appointed by the central government. However, it does not provide how the central government will decide who is going to occupy that position, what would be its composition, and therefore it leaves a huge question mark on the independence of the board, which is essential because if a board is hearing, say, complaints against the government and the central government is appointing the board, it's essential that it has members that are unbiased and can look at the complaint from a third eye perspective, right? And in line with principles of natural justice. So that is a huge question mark right now. Impact on right to information. So the Act actually amends the Right to Information Act in India, which has been sort of really important for civil society in the past years, where civil society files RTI, right to information applications, with the government, with private bodies, etc., to get information on issues before they address them. The Right to Information Act in India has an exemption provision, which says that in certain circumstances, the person from whom or the body from whom you're asking for information can deny information on certain grounds. Now, this Act has amended the exemption provision in the RTI Act to include, and I would quote, information which relates to personal information. So basically, any information that relates to anyone's personal information can be denied in an RTI application, which again is really broad because a lot of information is personal information at the end of the day these days, right? So it really impacts the Right to Information Act in India, which is something that civil society is trying to fight now. There is excessive delegation because a lot of procedures as to how the Data Protection Board will be constituted, etc., have not been put in the Act, and it has been deferred later to the forming of regulations, which will determine these issues, right? Then there are penalties for data principals, of course. What is surprising is that there is no penalty for a data principal in case of a breach if the data principal shows that they have taken reasonable security measures to prevent a data breach. Ferdhi showed you data on the amount of data breaches that have happened in Indonesia. We have similar figures in India. And what is surprising is that a data fiduciary can actually get away with paying any penalty if they show that they took some security measures which are considered reasonable by the board to protect them, right? And then, the data fiduciary will not have any, recourse if it's found that security measures would have been taken and there's damage caused already, the data has been breached, right? That is also one of the most problematic principles that civil society is fighting in the Act. And then...
Sorry, can you wrap up in 1 minute?
Yes, okay.
Thank you.
And the last provision is about additional obligations to significant data fiduciaries. So this is where I think there's a huge impact to civil society. The Act clearly says that it is going to list down certain fiduciaries as significant data fiduciaries on the basis of certain factors. These factors include the volume or the sensitivity of personal data that the organization is processing, risks of rights to data principle, risk to electoral democracy, security of state or public order, right? Now, given how civil society functions, its actions at times are not in consonance with what the government is doing, right? So this provision can be used to notify a civil society organization as a significant data fiduciary. Now, a significant data fiduciary has additional obligations like appointing a data protection officer, doing regular audits, appointing an independent auditor, doing a data protection impact assessment, etc., which highly increases costs for civil society in India. One of the struggles of civil society in India is to get enough funding to get the wheels running in an independent manner, right? And this may really impact compliance costs as well as the operations of civil society, and it may, affect their output negatively. So this provision is something that civil society has to watch for. We don't have enough data yet to see how it's going and who's complying as much because the Act was just passed. But we hope to know soon how it's doing in India, and civil society is already fighting on the points that I flagged for you.
Thank you, Anandita. So even just between these two countries, India and Indonesia, we can already see shared challenges. But these two countries, we have just we just issued our laws So we want to hear from a country which has already had some experience of implementing the law, and to hear more about the, of course, about the problematic provisions, but also on the adverse repercussions of the law. And Maristela here, as a practitioner, as a data privacy practitioner, she can also share about what civil society can actually do to increase their resilience amid these challenges. Maristela, over to you. Please put the slides on, please.
So good morning, everyone. So I will keep this as short and as simple as possible. So I will not be really talking about the law itself, but how we apply it in the Philippines and how it affects the people's rights. So this is data privacy in the Philippines, the tensions between privacy and civic freedoms. Oh, okay, it's changed. Why is it like that? So anyway, so data protection laws, we know what its main goal is: to ensure that anything that you do with personal data will be lawful, that it will protect the human rights. But we also recognize that it is not meant to restrict any flow of information. We just want to make sure that everything is made legally and in respect of the rights of the people. So, however, as seen there, though it changed the slide. So anyway, these laws are sometimes prone to abuse, whether in full or partially. So how are they infringing on the rights of the people? So we will see in the next slides. So what we have here are some examples on how the Data Privacy Act is actually misinterpreted, whether it is parts of it are misinterpreted, or as a whole it is misinterpreted. And when it is invoked, it actually prevents people from exercising some of the rights. For example, the Securities and Exchange Commission took down their system, which prevented the journalists from checking dummy accounts in the Philippines. And the other is when government officials are actually denying access to their statements of assets and liabilities and net worth. So it prevented the public from seeing which politicians or public officials are actually involved in fraudulent and corrupt practices. And I want you to look at this section. So our Data Privacy Act, it has some exceptions. And one of those exceptions is when personal data is going to be processed when it is necessary for public authorities to carry out their functions. So it is under the exception. But it is only to the minimum extent necessary, which means that you still have to uphold the rights of data subjects, ensure the security of personal data, and uphold the privacy principles. But if we read this together with the next slide, we can see here that even if they are outside of the scope of the Data Privacy Act, it is still included in the criteria for processing personal data. So if we see it in one way, like it is the government wants to ensure that it will be able to process personal data for its purposes. So one thing, they say it's not covered, and then in the other slide, we can see that it is part of the criteria for processing. And why is this prone to abuse? Why is it dangerous? Because in the Philippines, if you know of red tagging, so red tagging means you are labeling individuals to be communists or against the government. So anything you say that is against the government can be interpreted as something that is for communists or terrorists. And we've had examples like this one. So during the pandemic, we had what we called community pantries. So community pantries are self-organized, like mini stores where people can line up and get what they need. But then police started asking questions who these people are and asked them to fill out forms asking which organizations they belong to, what are they doing there, etc. So the people were actually scared. They stopped doing it for a while. And there had been instances that the people who volunteered were actually red tagged. And it's not the first time that this happened in the country. Next slide, please. It also happened with a group of teachers. So ACT is a group of their Alliance of Concerned Teachers. So they are a progressive, militant, and nationalist organization of teachers and other workers in the education sector. So the Department of Education requested for this certain list of individuals or teachers who availed of the automatic payroll deduction system. So if we look at it, it seems harmless, but the teachers got scared because a previous instance where a list was got from the teachers or the schools, it was used to label again the teachers as communists, as terrorists, and the group said that consent was not obtained. But if we look at the provisions earlier, we can say that consent may not really be necessary in this case because the Department of Education can easily say that they need it for their function as a public authority and for the legal obligation of the school to provide these names. And it also happened with a group of lawyers. So lawyers who represent those who have cases against the government are labeled also as supporters of communists and terrorists. And also this DILG, or the Department of Interior and Local Government, they also requested for a list of their employees who are members of this certain group called Courage. And of course, the fear is there because red tagging is happening within the Philippines. But let us now look at how this affects CSOs. What does this mean for CSOs? So this is more of the organizational effect to the organizations. So there's the lack of funds. So what do we mean by lack of funds? Because you need to comply with the data protection law, it means that you need to have some funds to do it, not just to protect personal data, but because there are certain requirements like registering your data processing systems, appointing your data protection officer, that requires funds because that is not part of the usual budget that they have. And this also requires funds because when you file a complaint with the National Privacy Commission and you request for an investigation, there's a fee for that. And when you request for an advisory opinion or legal research, it requires funds. And if you look at the second photo on my left, so it says guidelines on administrative fees, and below that are actually the penalties under the Data Privacy Act. And you can see that there are fees if you do not follow the privacy principles, if you violate the data subject's rights. So if the organization is not ready, like what they have mentioned, if the organization is not ready, they are most likely will violate the Data Privacy Act and it will entail costs. And then the lack of manpower. So we know that they have to designate a data protection officer, and not all organizations have data protection officers. So what they do is they just appoint someone already in the organization to do the responsibilities of that officer. And they cannot hire somebody else because of the lack of funds. So it's like you have this one problem with funds and then it affects all the other requirements and capacity of the organization to comply. Next is the lack of data protection training or data privacy training. So even if you have people, if you have designated a data protection officer, it doesn't ensure that you will be able to comply because not everyone knows how to interpret the law. Not everyone knows what to do. So it was common for us to encounter organizations who do not know where to start their compliance. And it is common also in the Philippines to have organizations who have policies who are not documented. So they follow their own practices, they follow verbal policies, but it's not written down. And we know that part of a robust privacy program is to have things documented, to make sure that it will be uniform across the organization and it will not just change from day to day. It will not change with just because you think that this should happen. So it is common to encounter this. And when you are unfamiliar with the other data protection requirements, if you're an organization that processes personal data of foreigners, and it is still covered by the Data Privacy Act, let's say. So if you don't know which requirements apply to you, then you are most probably be already violating some of those data protection laws. So what does this have to do with their image? So if you do not comply as an organization, you may damage your reputation because there are a lot of data breaches happening and people are becoming more aware of their rights. So if they do complain through social media or the National Privacy Commission, then your reputation would be damaged. You will lose the trust of your beneficiaries, members, partners, or even funders. And there are legal repercussions. In the Philippines, if you've noticed earlier, it's not just paying fines. The DPA or the Data Privacy Act says that you will be imprisoned and you will have to pay a fine. So that I think is one of the unique characteristics of our law. Do I proceed with a? Sure. Okay. So how can the CSO stay resilient in the face of potentially repressive data protection law compliance requirements? So of course, you need to upskill. You need to upskill the people in your organization because the laws are always changing. There are always circulars being issued by the commission, and you build the capacity so that you will ensure compliance and a change in the culture of your organization. You should also know where or when to stand your ground, because it's not always the case that when the government asks for information, it's always legal. So you have to know the grounds wherein you can deny access to information to protect also the people in your organization. You should also include data protection in your budget considerations because we've seen earlier that it requires budget to comply. So how can CSOs participate meaningfully in policy processes, implementation, and data privacy advocacy? Of course, you have to actively participate in all policy-making processes. So like this one, you need to get involved in public consultations and forum. If there's the submission of position papers, you do it as an organization. You need to extend research support to policymakers because not all of those people who are deciding for our country know about the technicalities of such as the data protection. So you need to extend support to them. And for those with the capacity to do so, some CSOs provide free training to other CSOs. So that would be very helpful. And you should produce information, communication materials, education materials, and you should take advantage of social media. So it will spread your IEC materials pretty effectively. And what are the opportunities for a transnational civil society collaboration in the advocacy at the intersection of data privacy and civic freedoms? So collaborative research efforts, so between Tifa Foundation, maybe some other organizations in the Philippines and India, that would be really helpful, especially when our data protection laws have been around for quite some time, and maybe we can share some insights with their organizations. And we should express solidarity when dealing with common and critical issues. So as a nation and as a region, we should stand up and make our voices heard as a region in a group of organizations who believe that data protection should be upheld. And we should share and pool our knowledge and best practices and produce materials about it. And of course, the funding support. Funding support will really go a long way. And I think that's it for me. Thank you.
Thank you, Maristela. Thank you, Ferdhi, and thank you, Anandita. So Aris here is on standby to help us explore more and about the challenges in Indonesia, in relevant to your questions about the situation in Indonesia, because we have a lot of data breaches and we have a lot of problems even with the enactment of data protection law. So before we discuss further with the panelists, I would like to open the Q&A floor to all of you who are present here and also all in the Zoom meeting room. In case you have any questions, or I heard yesterday as well that colleague from Korea, from South Korea, also shares the same problem, the same challenges, in which the personal data protection law in their country has been instrumentalized to shut freedom of the press. So in case you also have any knowledge or experience about the same challenges, you might want to share and also discuss probably what has been the good practices that you have employed, which we can also learn from that. Is there any questions? Is there any raise of hands? Sorry. Okay, there's a question from Fred Goodert. I hope I do not pronounce your name wrongly. So related to the Philippines, can you share about the case of Jose Rizal Pajares, the reporter with Radio Natin, who was arrested by the Iriga City Police after trying to access police blotters under violation of the data privacy law, and how the law can be used against journalists? Maristela, over to you.
Yeah, so I've heard about that news, but I'm sorry to say that I'm not quite familiar with the case. Yeah, but yeah, the misinterpretation of the law and using it against journalists is not far-fetched. So it can be really used by the government to stifle any voice that is critical of the government. And it's common in the Philippines.
Thank you, Maristela. Is there any other question from the floor? Oh, not yet. But probably if we can also explore and hear from Aris. Are you on standby? If you can also share, do you have any experience of probably helping communities or data subjects to advocate for their rights to obtain some kind of compensation, maybe from the government over the breaches or violations of data, personal data protection rights? Aris?
Okay, thank you, Debora. Good morning, everybody. I just want to take you back to 2 years ago. In 2020, there was a massive protest in Indonesia regarding the passing of a job creation bill. So SafeNet, Southeast Asia Freedom Network, Freedom of Expression Network, recorded that there was 20 doxing cases, which were most of the victims were journalists and activists. So this data protection bill should be the answer for that kind of case. But right now we still, facing that kind of doxing cases in social media. There's a lot of. I just opened my social media, and still we still have that kind of personal data exposing by someone with no authorization on that. So about a week ago, we have a workshop in South Sumatra in Medan with Indonesian journalists about. We were talking about holistic security, and there was one very interesting question about this privacy issues in Indonesia. The question was, why should we protect our personal data? Because it's already there. I mean, there's a lot of breaches cases in Indonesia. So actually, we are open source country actually. So why do we have to protect our personal data? This is a question from a journalist. This is a very interesting perspective. I mean, it sounds desperate, but that's the reality. I mean, whatever the law applied, the governments always win. It seems that the general expression in Indonesia. But the point is, this law could be something if, but with condition. I mean, for CSO with a huge resource, it can be easily for them to, comply with the law. They can easily send their staff to digital security training or data management training or something like that. But for CSO that have a very low, budget, low scale, it could be a problem. And the recent development in Indonesia is many sensitive cases is happening in the remote area, which is, they are far from access to information, far from access to data security training, something like that. So this is a huge challenge for us in Indonesia. And I believe this challenge will getting bigger over the years, because right now they are facing face-to-face with the giant mining company or plantation company, which very far from media sport. So I think, yes, I can say that this data protection law could be the answer, but in the other hand, this could be a backfire for CSOs in Indonesia. Back to you, Debora.
Thank you, Aris. So yes, you have heard, I mean, it's good that we have data protection law in place, but it is important to continue the advocacy so that the law that we want is there. So the law itself can be better improved to fit the needs of the people and also be more proportionate in imposing obligations and also in imposing and also putting in place sanctions for all of the stakeholders that is related to the law. And as we have heard from Aris earlier, that unequal level of awareness, not only between different data controllers in different sector, but even within the civil society sector itself is a problem. And in countries where urban and rural inequality is actually as high as Indonesia and maybe in the Philippines and also in India, civil society in the urban areas and also which have a lot more resources can have better capacity for compliance, but that is not the same case with civil society organizations in the rural areas. I would like to check again with the floor if there is any other questions or maybe remarks from you about the talks today. Raise of hand.
Debora, can I add? So yeah, so I searched for the case. So I read it, but I wasn't able to fully digest it before. So yeah, so the case was this journalist wanted to access the police blotter list so that he can create his news article. But then the police said that what he did was unauthorized processing of personal data, and it violated the confidentiality of personal data. So it is good that police are actually, they do have this procedure, but the question is, where is this written down? Where is this policy? Is this the same for everyone, or is this just this case wherein they don't want that journalist to access that information? So the journalist was detained, he was arrested, and he posted bail after 3 days. And it was 10,000 pesos. So that's the case. So it is balancing the right of journalists or the freedom of the press and the right to privacy. So in this case, it is still questionable.
For the addition. And I mean, like Tifa Foundation, even though we are the organizer of this session, we are also working on these personal data protection issue. We understand that, for example, not only that we have to increase the capacity of civil society organizations itself in terms of compliance, but we also need to strengthen these, if you can call it, network of support, because not all of these capacity can exist internally within the civil society organizations itself. You will still need, for example, legal experts public advocates, public advocates who have the skills, who have the knowledge about how to advocate for the privacy violations of the vulnerable communities, for example. And you will also need a public advocate who can advocate for the press freedom in the face of the repressive, quote unquote, personal data protection law. And you will also need digital security and safety experts outside of your organization who you can always contact or ask for help from in case of data breaches and so on and so forth. Because the burden of compliance, burden of proof of compliance lies in the data controllers. And in this case, civil society organizations themselves. So not only private sector organizations, not only public sector organizations, but also media organizations and civil society organizations. And I believe we can also learn from what Combined Resource Institution has been doing around increasing the capacity of vulnerable communities and groups on their personal data protection. They are actually focusing on groups which have not received any training on digital security and data privacy yet. So even if you are an organization that provides this kind of capacity building, you need to have that kind of needs assessment first, right? When you want to target the kind of groups that have not received any kind of training in this space, and you want to invest in that. And for example, Maristela's organization is also helping with even more advanced, I would say, step, which is developing the privacy policy of civil society organization and other organizations so that they can comply more with the personal data protection law. And Anandita here helps with the litigation efforts around digital rights, but that will also include, I believe, data protection with the enactment of personal data protection law in India. I think we only have 3 more minutes. So if there is no other questions from the floor or from the Zoom, I would like to give the last opportunity to also for Anandita, if you can share just a bit with the enactment of the data protection law and with the concern around Aadhaar. I hope I pronounce it correctly, the digitized welfare system, Aadhaar. If you can share briefly what civil society which work with these vulnerable communities can do to ensure that with the enactment of the law, their data, personal data particularly, that is processed in Aadhaar system can still be protected.
Okay, so earlier the Supreme Court of India, when it recognized the right to privacy a few years back, had said that not having an Aadhaar card or not having an Aadhaar number cannot remove you from the number of people who are getting services. Basically, if you don't have an Aadhaar card, they cannot say no for you to get services. There was no data protecting your personal information associated to Aadhaar then until now. Aadhaar records your name, your phone number, your email, your address, your fingerprints, your retina scans, right? It's a lot of sensitive personal data, not just personal data. As of now, as per the Act, there is protection granted if you give your consent to your data being processed for the purposes of getting the service. However, the Act very clearly says that if you withdraw that consent, the data principal will have to bear the consequences of that withdrawal, right? So if you withdraw your consent, say for a particular thing that is being processed under Aadhaar, you may not get the services that you want, which is problematic. You do not need my retina scans probably to give me access to the public distribution system to get wheat, right? So the Act is very blurry on that. And it may affect services if somebody wants to withdraw their consent, but it also provides provision for protection of that data. It does.
Thank you, Anandita. Not to leave you, not to finish this session with a pessimistic note, but please, even if you think you are not that aware about the data privacy landscape in your region, please, after this session, you can probably spend some more time to look at how the threat landscape for data privacy in your country is, and get in contact, get in touch with us. We look forward really to actually forming alliance of data privacy activists, advocates, whatever you call it, so that we can make even bigger impact, not only in our own jurisdictions, but also globally and also regionally, Asia Pacific at least, in terms of having more rights respecting and also proportionate data protection law, and more needs-based capacity building for civil society organizations around Asia Pacific. I think I will finish this session and on that note. Thank you for participating in the session, even though you do not raise your hand, but I'm sure that we will still be in contact even after this session, even during the coffee break. Thank you, everyone, and thank you, everyone in the Zoom session.